everyone. My name is Karen Brindisi. I am a program attorney at the National Council of Juvenile and Family Court Judges. I would like to thank everyone for attending this wonderful session today. We have two amazing speakers who are going to teach you, and hopefully we can learn from you as well, a little bit more about the Take It Down Act. I will leave it to them to introduce themselves, but first I just wanted to do a couple housekeeping matters. We are recording this presentation. If you can leave all of your questions, either put them in the chat or leave them until the end, we'll try to leave some time for questions at the end. And we have a kind of follow-up webinar scheduled for this same time next week, August 25th. So we hope to see you then as well. And with that, I will turn it to Tony and Belle to do introductions.
Hi, I'm Tony McKinley. I'm a lived experience expert and I'm an LPC supervisor out here in Texas. I've been working with survivors for a long time, since about 2011, but I also operate a home for women 18 and older, long-term therapeutic residential home of survivors of trafficking.
Hi there, everyone. I'm Belle Torek. I'm an attorney by training, and I'm a senior technology safety specialist with the Safety Net Project at the National Network to End Domestic Violence, or NNEDV for short. My background has been at the intersection of online speech and harms for over a decade now. I've especially been working around issues of image-based sexual abuse since about 2017. So it's really a privilege to be able to speak on this topic today. And I'm over the moon to be here with Tony and our partners at NCJ FCJ. So I'm so thankful to them and to you all for being here. So today we're going to talk about the Take It Down Act, but we really do want to do two things at once. We want to give you a useful understanding of what this new federal law actually does, and we also want to make sure that the law never becomes disconnected from the people, the survivors, the harms that prompted it. For judges and court professionals especially, I think that context matters deeply. These cases can look like technology cases on paper, but in practice they are often cases about broader issues. Think about ideas like safety, coercion, privacy, dignity. So our goal today is to give you enough of the landscape to recognize what may be happening if and when these issues appear in your courtroom, and to help you understand what this new federal framework changes. Before we get started there, just our regular funding disclaimer. This program was developed with support from the Office for Victims of Crime through both NCJ, FCJ, and NNEDV's Safety Net Project. As you can see here, the views expressed today are those of the presenters and contributors and don't necessarily represent the official positions of DOJ, NCJ, FCJ, or NNEDV. And with that housekeeping out of the way, I want to begin with the harm itself. So the first thing I want us to hold on to throughout this presentation is that these harms are not just online. I know that we've kind of created this false dichotomy in which we consider distinctions between online and offline harms, but that binary never really existed, and I think that we can all agree that it's collapsed, especially in recent years. Technology may be the mechanism through which an abuse or set of abuses occurs, but the effects do not remain neatly confined to a device. So an intimate image posted online can affect whether a young person feels able to attend school. It can affect familial relationships. It can become part of stalking or coercive control. It can affect a survivor's housing, employment, community standing, willingness to participate in court proceedings. And one of the things that I think is most compelling here is that in recent years, we've discovered that an underlying image need not even be authentic. So courts and helping professionals are now encountering AI-generated intimate imagery, sextortion, coerced image sharing, and other forms of tech-facilitated exploitation that may have existed before, but have metastasized to newer technologies and that are manifesting in new ways. And with young people in particular, the person in front of the court may not fit neatly into a box marked victim or offender. So the through line I'd like to establish at the outset is this: understanding the technology should help us to understand the human harm more accurately. It shouldn't distract us from it. So here's how I want us to approach that. We're going to start today with the harm, what we mean by image-based sexual abuse and why it matters. Then we're going to take a step back and look at the history, because this problem, again, didn't begin with generative AI. This may have been when it entered more common parlance and became more popular, but this is a much older issue. Technology has changed the scale and accessibility of the abuse, but the history matters deeply. And from there, we're going to turn to the law, what the Take It Down Act prohibits, whom it protects, and then we're going to talk about the response, especially the new notice and removal obligations for online platforms and some of the practical realities that may complicate takedown for survivors. And finally, we're going to leave you with a litany of tools and resources that may be useful if and when these issues arise in practice for you. So, what is image-based sexual abuse? Before we get into the statute, I want to give us a common vocabulary so we all understand what we're talking about from the get-go. You're going to hear us use the term image-based sexual abuse. I like that as an umbrella term because it keeps our focus on the abusive conduct rather than on one technology or how one image came into existence. It also does a really good job as an umbrella term of encompassing a series of different harms. So within the image-based sexual abuse umbrella is non-consensual intimate imagery, or NCII. Those are intimate images that are distributed without the consent of the person depicted in those images. That can involve an authentic image, but increasingly it can also involve a synthetic or deepfake image. Someone can take an ordinary photograph from a social media profile and use readily available technology or nudification apps to generate an apparently realistic, sexually explicit image of that person without their knowledge or consent. We also include sextortion in this broader landscape. Sextortion is sexual extortion using intimate imagery or the threat of its disclosure as leverage to obtain money or conduct or anything really. Often other forms of compliance, additional images. And then there are cases where intimate imagery becomes part of broader trafficking or exploitation. So these categories can and do overlap often. What matters the most, I think, is recognizing the common threads here. Sexual imagery being used without meaningful consent as an instrument of exploitation or control. So before Tony takes us more deeply into the psychological and traumatic impact, I want to take a moment to widen the lens for us, because the harms of NCII are much broader than emotional distress alone. At the most fundamental level, there is a loss of privacy and bodily autonomy. Someone else has taken control over who gets access to an intimate representation of your body, or with a deepfake, a representation of your body that never existed in the first place. There can also be concrete safety consequences. So images may be accompanied by names, addresses, workplaces, and other personally identifying information. In abusive relationships, the posting itself can be part of stalking and escalating patterns of abuse and control. There are reputational and social consequences. So for a teenager, for instance, that could mean an entire school community. For an adult, it could mean coworkers, family members, faith communities, professional licensing communities. And there's a significant practical burden associated with trying to make the content disappear. Survivors may spend hours or days trying to identify copies or near copies of a non-consensual intimate image, contacting platforms, documenting URLs, the links that direct to the harmful content, talking to attorneys, seeking out resources, trying to determine if something has surfaced and when. And that leads us to the last important point here. digital persistence, which basically means that unlike many forms of abuse, a survivor may never know when the incident is truly over. That's because a copy can be saved, it can be reposted, it can be altered with just a few pixels off and not necessarily be tracked so easily. It can move and metastasize to other platforms. So when we call this image-based abuse, that terminology is intentional. The injury is not just embarrassment or discomfort, it can reach nearly every domain of a survivor's life and often does. And that persistence, the sense that the harm can return at any moment, is part of what makes it so pernicious. Survivors are often forced to leave online spaces, their schools, their workplaces, and public life in order to avoid further exposure and re-traumatization. There's a chilling effect on speech and democratic participation, and a myriad of harms. So, Tony, I will turn it over to you.
All right, thank you. So this slide is really just, it's really just one image and one point here. And I want to just let you look at this and sit with this for a moment. It's about trauma and technology. So it's real harm from fake images. And these intimate images can be spread rapidly, as we mentioned just a minute ago, online, and they can be extremely difficult to remove once they're out there. So victims or survivors, they will endure this ongoing fear and shame and humiliation when this is done to them. And, I use the word victim because it applies even when the image itself was never really real. So whether it has just their face or a certain part of them, the whole thing may not be them or just be completely made up and it's not real at all. So that's really the whole point of the slide, is that these deep fakes that are out there can cause the same psychological harm as a real image. And that's important to really know, because a lot of people assume that it doesn't because it's not the real image, but it does produce the same psychological harm as a real image. The image can be entirely fabricated, generated from start to finish by AI, and the person it depicts still experiences it as a very genuine violation of them. So the technology being fake doesn't make the harm fake. And I think that's really important to distinguish, that even though the technology made about them is fake, it doesn't make the harm fake that they are suffering and enduring. So NCII, which is the explicit or images, and also the digital sexual violence, are associated with depression. Survivors will experience anxiety. They'll have a lot of shame. It causes isolation. And also it can cause suicidal ideation. And that's not a rare effect at all. It's actually a very well documented pattern that happens when this kind of stuff happens to youth. The humiliation can feel just enormous. So you have the schools, their peers, family, if they're involved in sports, or if they're in a faith-based community, or all of their online life through all their apps and social media, all of that collapses into really one inescapable environment. And there's no version of their life that feels safe from this. So in sextortion cases specifically, the threat of exposure itself can become acute and life-threatening. Not the exposure happening, but the threat that it might happen. So for many survivors, the trauma, it just doesn't stop once they decide to seek help. A lot of people assume that they get help, so the trauma stops or they feel better. One of the most overlooked realities is that the reporting and the takedown process itself can really become re-traumatizing. And I experience this with survivors a lot, who are afraid to go and search, even search, knowing that they're out there, afraid to go and search for images of themselves because of that re-traumatization and re-experiencing that. And we're often asked to locate these images ourselves and to describe them and what's happening, what's going on, to identify where they're posted at, and sometimes look at them again in order to report them. So they may have to repeat that process on multiple platforms, because there's so many social media outlets that this could be exposed to. and even more so ones that we probably have never been on ourselves. So imagine trying to heal while repeatedly being asked to revisit that very violation that you're actually trying to escape. Every report can become a reminder of what happened. And that's why that trauma-informed response really matters, not only when someone first discloses, but throughout the entire legal and reporting process. So as you see on the slide here, a systematic review found evidence connecting NCII among youth with depression, anxiety, and suicidal ideation. And an FBI and Homeland Security investigation and NCMEC alert reported that there are more than a dozen minor sextortion victims died by suicide, amidst the sharp increase in these cases being reported. So it's just something to keep in mind and take note of how this has such a negative effect on our youth. So let's talk specifically about what makes the youth vulnerable in these cases. There are 5 things that I want you to really think about, especially when a young person's own conduct is part of what's in front of you. So first, it's that heightened social vulnerability. We know that adolescence is already a period of intense social sensitivity, and this kind of exposure lands on top of that and not into this a neutral space. And then the second one is the peer humiliation. It's absolutely catastrophic for them. And for an adult, also, this is devastating. But for a teenager whose entire social world is often still their peer group, it can feel like the end of everything that matters to them. And the third one is that adolescents, they may not grasp permanence or redistribution risks. So a young person may genuinely believe an image sent to one person stays with that one person. And the brain science on this, on risk assessment and long-term consequences, just fully developed yet at that age. They don't understand it. And so that's something to look at as a vulnerability. And then fourth, this is, it's grooming and coercion. So they are sometimes mistaken for consent when youth is groomed and coerced into some of these things. So a young person going along with something, even appearing willingly in that moment, is not the same as freely consenting to it. And we need to remember that as we're looking at this. And the fifth one, the last one, is that following youth may participate in this conduct while under pressure, while under having extreme fear or dependency, or under the control of a trafficker. And what looks like a choice on the surface may not be one at all. So all 5 of these are here because they matter directly for how you read role in a case that comes in front of you. All right. And go on to the next slide.
Thanks so much, Tony. So I think that it's really important to talk about exactly how we got here, how we reached this moment. And I think that the easiest way to understand the urgency around Take It Down is to recognize that this is an incredibly old harm meeting increasingly powerful distribution and creation technologies. Many of us first encountered this issue under the label revenge porn. How many of you, show of hands or in the comments, how many of you have heard that term before? Fantastic. I'm thrilled to know that folks are already familiar with it. Excellent. This term was very popular quite a while ago. I tend not to use that term, and I think that the field at large has moved away from it, except when we talk about this historically, because it suggests revenge is always the motive, and it describes the material as pornography rather than focusing on the absence of consent. But early dedicated websites made very visible what happens when intimate images can be published at scale. Then social media and messaging services transformed distribution such that one person no longer needed to operate a website. An image could move through a school, a workplace, a community, a subreddit almost instantaneously. And sextortion added another dimension, which is the image itself becoming leverage, which is why we've seen significant increase in sextortion cases in recent years since the advent of generative AI, because it is so much easier for someone to misrepresent who they are, to build rapport with another person, to vulnerabilities, and then to engage in sextortion. So, generative AI has changed the creation side of the equation significantly. A perpetrator may no longer need an authentic, intimate photograph at all. A perfectly ordinary photograph, literally anything available through a Google image search, could become the raw material for synthetic sexual abuse. Even a still image can be turned into a video depicting non-consensual intimate imagery. It's really concerning stuff. So there are two trends happening simultaneously. Distribution has become basically frictionless, and creation has become dramatically easier. So that combination is what creates many of the contemporary challenges we're discussing today. This is a controversial take that I'm probably not going to share a ton outside of the context of this webinar, but in a certain way, if you all remember what happened with Taylor Swift and those deepfake images in early 2024, I think that it was a really unfortunate incident, but I do think that it was a helpful catalyst in shedding light on this issue and bringing to the public the gravity of this harm. Because up to that point, we were in this moment of victim blaming and slut shaming, where we would say, oh, if someone didn't want that image out there, then she shouldn't have been in that photo. But now we've reached a moment where literally anyone can be the subject of a non-consensual intimate image, which is why now everyone needs to care if they didn't already. So, a little bit more on the legal system and the ways in which it has had to catch up with each of these technological shifts. Historically, one problem was the patchwork nature of state law. I remember this really well through my time at the Cyber Civil Rights Initiative, which was the first organization that identified non-consensual intimate imagery as a harm that required legal recourse. And back then, we were working at the state level, one at a time, trying to get these laws passed. States developed different NCII statutes at different times with different definitions, different intent requirements, different remedies, just a super uneven patchwork. Synthetic imagery created another challenge because laws written around the disclosure of an existing intimate photograph didn't always map neatly onto an image depicting something that never actually occurred. There were challenges of jurisdiction. The victim, perpetrator, platform, server, and audience can all be in different places, which complicates things. And even when the law clearly recognized the underlying conduct as wrongful, the survivor still faced another problem. How do I actually get the image taken down? So legal accountability after the fact and harm reduction in the moment are two very different questions. A survivor may be successful in reporting one post only to discover copies on 3 other services. Different platforms historically had different policies and different enforcement mechanisms. And of course, we know the platforms also have different reporting interfaces, different response times. So when it came to a survivor seeking takedown of a non-consensual intimate image, your mileage may vary. And that gap between recognizing the wrong and stopping its continuous circulation is a major part of the story behind Take It Down. And one of the cases that brought that gap into especially sharp public focus involved a teenager in Aledo, Texas. And I will pass it off to you, Tony.
Yeah, so in 2023 in Aledo, Texas, a high school student was subjected to AI generated explicit images of themselves. And it was shared on social media among their own peers. And these weren't real photographs. They were fabricated and shared among their classmates. It was shared in the school community without any real legal mechanism to address what had just happened to the kids. So that incident is what exposed in a very concrete and public way just how unprepared existing law was for this kind of digital exploitation. And there was no clean answer for the families at all, for the school, or for law enforcement to do what would be next. So that gap played out in a real school with real students, and it's what drove the development of the Take It Down Act and its eventual passage. So, this isn't an isolated story just in Aledo, Texas. It's just illustrative. It's the same basic patterns have played out in schools and communities across the country. And Aledo is just the case that got enough attention to move legislation. And so we're going to walk through the actual legislative timeline here briefly. So this bill was introduced not too long ago. It was in January of 2025 by Senator Ted Cruz, and it was enacted in May of 2025, signed by President Trump. And as of May 2026, which, was just a few months back, the platform notice and removal requirements, and that's the part that actually obligates platforms to act, it became enforceable just this past May. And that's an important distinction because the law existed before that date, but the enforcement mechanism against platforms didn't fully kick in until then. So the purpose, in plain terms, is combat the non-consensual sharing of intimate visual depictions, including the AI-generated content. And it's worth placing this in context. It's part of the broader wave of digital safety reform, not a standalone or even a one-off bill. Let's go to the next slide. So what this act actually does is, first, it creates federal criminal prohibitions for knowingly publishing or threatening to publish covert intimate images. And it sounds like a tongue twister for me, but no, it's the threat alone can be enough. That's important to know, that the threat alone can be enough. The image doesn't have to actually go public for this to apply. And second, it covers both authentic images and qualifying digital forgeries or deepfakes. And this is the piece that closes the gap we talked about in a few slides back. The law finally contemplates a fabricated image, not just a real one. And third, it protects adults and minors both, with enhanced penalties where minors are involved. And then the fourth one is it creates the FTC enforced notice and removal obligation for covered platforms. And this is the mechanism that actually puts that teeth behind the takedown request, which we'll get to more shortly. And these four pieces, the criminal liability, coverage of the synthetic images, protection for both adults and minors, and the enforceable platform obligations, are really the whole architect of what this law is. Okay, so here's some common misunderstandings of the Take It Down Act that I want you to see. There's 5 things that people commonly get wrong about this law, and we're going to go over the misunderstandings and then the actual answer. So the first one is only real images count. And this is false. AI generated synthetic images, they qualify if they appear to depict a real minor. And the image doesn't have to be authentic for the law to apply. The other misunderstanding is only adults can be charged. And this is false. The law applies to both adults and minors, though this is important to note, judges retain discretion in how they apply that law to youth. And I think we're going to cover a little bit of that later on or even next week in our next webinar that we're going to do about this. The next one is platforms are the only ones that are responsible, and that is false also. The act establishes criminal liability for individuals who knowingly distribute these images. So this isn't just platform accountability, it reaches the person doing the sharing also, who is sharing the images. Another misunderstanding is that judges can't enforce takedowns, and this is false. Courts can issue specific removal orders directly to the platforms. And the last one, the youth who share images must be guilty. And this is false. And pay attention to this, many youth are coerced, groomed, or trafficked. And safe harbor protections and trauma-informed review are critical here. It's a young person's involvement in sharing an image is not on its own proof of culpability. And that last point connects directly back to what we talked about a few slides ago with youth vulnerabilities. Apparent participation is not the same as guilt. So the next slide is some key definitions here. I got 4 terms precisely here. These are the actual elements of the charge. It builds directly on these definitions. So the first one is intimate visual depiction. This is nude or sexual imagery. That's the baseline. What actually has to be shown for this to even be in scope. There's also synthetic content. This is AI generated or digitally altered imagery. And this is what allows a fabricated image to count the same as a real one under this law. And the next one is the non-consensual disclosure. This is sharing without the subject's explicit permission. So notice the word explicit. This isn't about implied or assumed consent. It has to be actual permission. And a covered platform, which is online services housing user-generated content. And this is what determines which platforms actually have obligation under the act. Not every website, specifically ones hosting content, that their users post. And then, so we're going to walk through exactly how they combine to form an element of an actual chartable case here in our next slide, which I believe is you.
And I want to clarify something really quickly for everyone. A synthetic image, under Take It Down, regardless of whether the person depicted is an adult or a minor, all of that counts under the act. I know that we are focusing extensively on young people for purposes of the conversation, but just want to make sure that folks know that this applies across the board.
Yeah, thank you for clarifying that.
And this is the slide where I want to put my lawyer hat on for just a moment and add a caveat. So this is a high-level orientation slide, not a substitute for walking through the statutory text in a particular case, of course. The Act actually creates different pathways depending on whether the depicted person is an adult or a minor, and whether the image is authentic or a digital forgery or a deepfake. So one thing I especially want to clarify verbally, the statute uses the concept of knowingly publishing the image, so I would not treat recklessness as a freestanding mens rea requirement under Take It Down. For an authentic image involving an adult, the statute looks at things including whether the publisher knew or reasonably should have known that the depicted person had a reasonable expectation of privacy, whether the conduct depicted had been voluntarily exposed in a public or commercial setting, whether it was a matter of public concern, and whether publication was intended to cause harm or actually caused harm. We have at Safety Net actually written extensively about this because we know that there are pros and cons of any piece of legislation. A blog post that we published the day that this was signed into law, I've just placed in the chat for you all for reference. Let's see. So for a digital forgery involving an adult, lack of consent becomes an express element, along with the public exposure, public concern, and harm requirements. For a minor, the framework is a little different. Whether the image is authentic or a qualifying digital forgery, the statute focuses on knowing publication with the intent to abuse, humiliate, harass, or degrade the minor, or to arouse or gratify sexual desire. And across these provisions, identifiability matters. So the statute also expressly tells us something very important about consent. Consenting to the creation of an image does not establish consent to its publication, and sending an intimate image to one person does not establish consent for that person to publish it and share it with others. That distinction is enormously important in many NCII cases. So the practical takeaway from this slide is this: when an issue arises, it is so important to slow down and identify which statutory pathway you're actually analyzing before assuming that all of the elements are interchangeable, because they are not. Now we turn to the other major half of the statute. This is my bread and butter personally. It's the platform response. So as Tony mentioned earlier, as of May 19th of this year, huzzah, covered platforms are required to establish a notice and removal process. And Congress was fairly specific about what that process must look like. The platform must provide clear and conspicuous notice of the process in plain language. An identifiable person or someone who's authorized to act on their behalf can notify the platform that an intimate depiction appears on the service and request removal. A valid written request includes several things, right? It includes a physical or electronic signature. You have to include enough information for the platform to locate the content. It requires a brief good faith statement that the content was published without consent and sufficient contact information so that a platform can get back to you. Once the platform receives that valid request, the clock matters. It must remove the depiction as soon as possible, but no later than 48 hours from the time that valid request is submitted, and it must make reasonable efforts to identify and remove known identical copies. That last phrase is worth noticing. Known identical copies. I'm saying it over and over again for emphasis. Congress didn't write a general requirement that a platform guarantee the image can never appear anywhere again. And the enforcement mechanism is also really important for this judicial audience. Failure to reasonably comply with these obligations is treated as an unfair or deceptive act or practice, and it is enforced by the FTC. So this section creates a federal platform obligation, but it's not simply a new source of generic takedown order authority for every court. This is where I want to put on my safety net hat again, because a statutory takedown right is enormously meaningful, but takedown is not the same thing as permanent absolute erasure. The first practical problem here is fragmentation. So an image can move from one mainstream platform to another platform. It can move into a group chat. It can move onto a website. It can move onto someone's personal device, rinse and repeat. It can happen all over again. Removing one copy, regrettably, doesn't pull every copy back into the ether. Second, platform capabilities vary enormously here. A large platform may have super sophisticated trust and safety infrastructure. A smaller website may have a completely different capacity. Private and encrypted environments present their own technical constraints here. Importantly, survivors often face the exhausting burden of navigating multiple reporting processes at exactly the moment that they are already in crisis. Tony spoke a little bit about this. And then there is, of course, the problem of re-uploading. So one intervention you may hear about is called hash matching. A hash is essentially a digital fingerprint derived from an image. Tools like NickMix, Take It Down, and stopncii.org can create a hash on the user's own device, meaning that an intimate image itself doesn't need to be uploaded to the service. Participating platforms can then use the hash to identify matching copies. Just about every major social media platform is part of one of these takedown services, and although hash matching isn't expressly written into the language of the Take It Down Act, this seems to be the mechanism by which platforms are complying with the platform's obligations. So far, it appears to be the most effective mechanism. That can be really powerful for exact or recognized matches, but again, it's not magic. Content can migrate outside participating services, and technical changes, changing even a couple of pixels or slightly editing an image, can affect the degree to which a matching system can detect that image. So I want to leave you with this distinction. The law can create an enforceable removal process. Technology can help reduce redistribution, but unfortunately, neither of these guarantees that every copy everywhere ceases to exist. And that uncertainty is one of the reasons that survivor safety planning and support remain essential even after successful takedown has taken place. Tony, I'll hand things back to you to bring us home.
All right. So I want you to just take a moment here and really think about this one single question. What does justice look like when the harm is digital? You've heard the practical limits of Take It Down, like the 48-hour requirement, the copies that keep circulating, the reposts that happen. So this isn't a rhetorical question. It's the actual question in front of you every time you see one of these cases land on your docket or on your desk or somehow within your professional life. what does accountability or relief or protection actually look like when the harm itself lives online and doesn't fully go away? What does that look like? What does relief look like? We just heard that we can't guarantee every image can be taken down, right? So that harm doesn't fully go away. I don't think there's really one clear answer, but I want to just give you a moment to actually hold that question rather than really rushing straight from here's the laws and limits into here are some resources, and just really think about the harm that this has done and may continue to do to others. So we have some resources that we wanted to leave you here with. We have the full legislation text and summary at this link, and we can email this out to you guys afterwards. And it's not that difficult to read, but it's the bill text, the statutes, and the summaries. We also have stopncii.org, which is a free tool to support victims of non-consensual images and image abuse. And then the Take It Down national reporting platform there is also from NCMEC. And so a free tool for minors or advocates advocating for them. If you want to request the removal of some non-consensual images, you can go through that website and they can help you help facilitate that. We also have platform-specific reporting portals. So Facebook, so Meta, which would be Facebook and Instagram, and then also TikTok and Snapchat have reporting portals that if you see it on those sites that you can report it. There's judicial and multidisciplinary education resources. So, NCJFCJ, who you're here today with, and National Judicial College and the ICAC Task Force Program, also, which is Internet Crimes Against Children, if you didn't know. But it's all of these are resources for you to help you learn more and to help you fight against these images that are online. And child protection and digital safety partners like NCMEC is a big one. And Thorn has a tool for judges and law enforcement that you can use also. And we'll make sure you get all of these if, afterwards we can email them out. All right. So I think that leaves us with, we have some glossary of terms. I don't know if we were going to go over those, were we? Or just have it for you as a resource. But that's the end of our presentation here.
15
So
minutes of Q&A.
15 minutes of questions. Yeah. I
When
did
does that
see-
ever happen?
I know. I did see a question pop up, which I thought was really good. I had a feeling it would pop up, and it was about what platforms maybe aren't required. I'm not sure exactly what the question was. Do you have that, Karen, in the chat?
What the question is, what specific sites does the Take It Down Act apply to?
Yeah. I can tell you from what I read, what it doesn't apply to, and that would be like email providers, broadband internet providers, and certain sites consisting primarily of providers. Well, I don't know how to explain it because I'm not a big techie person. I don't know if you can, but provider selected rather than user generated content are just examples that it doesn't apply to. But I believe, and you can elaborate on this, TikTok, Facebook, Instagram, Snapchat, right? It applies to all those and many more sites.
Yes, so Tony does a really good job of bringing up certain points here. Unfortunately, the Take It Down Act doesn't apply to. There are sites that are designed specifically for image-based sexual abuse, Mr. Deepfakes type websites that are curated by one user, which doesn't operate the same way as the websites, the apps, and programs that Take It Down does apply to. So the Act doesn't give us a list of named websites, but it uses a functional definition of covered platform. So broadly, that could be a website, an app, an online service that serves the public, and it either provides a forum for user-generated content, or it's regularly in the business of hosting or making available non-consensual intimate imagery. So we're talking about potentially social media platforms, messaging services, image and video sharing services, similarly user-generated content services. The FTC expressly identifies those categories in its implementation guidance, which I can Google and pull up in a second. There are key exclusions, like broadband internet providers are totally excluded. Email itself is excluded. Primarily publisher curated sites are excluded when their interactive features are merely incidental. So I'd be cautious about saying, for example, like, here's the definitive list, because there is no definitive list. But for a particular service, you would analyze whether it falls within that definition. If someone says, does Facebook or Instagram count? Like, obviously, the major social media platforms all fall within the purview of take it down. These are services the definition is designed to reach by definition. But again, applicability ultimately depends on the statutory definition. Sorry for being so wordy.
No, that's what we need.
It looks like there was another question in the chat about if the poster's intent was to make money off the image, then the state wouldn't apply. I'm assuming they're referring to, does the state law apply in that situation? Oh, statute.
Statute.
I can take this one if you'd like.
Yeah.
So, a commercial motive by the poster isn't itself an exception to the act. For an adult victim, the statute says that the publication has to either be intended to cause harm or actually cause harm, including psychological, financial, or reputational harm. So someone might publish the image because they want to make money rather than because their subjective purpose is to hurt the victim. But if the publication actually causes the requisite harm and the other statutory elements are met, the adult provision can still apply. There's also another useful distinction. So I want to clarify one piece of statutory language that can be confusing because it threw me for a loop when I first read this. When the Act talks about material being voluntarily exposed in a public or commercial setting, that refers to what the depicted person voluntarily exposed, not whether the person posting it later was trying to make money. So a perpetrator monetizing an image is a totally different question. Oh, thank you so much for putting that in the chat, Karen. And I'll share my contact information too. Email, LinkedIn, and techsafety.org, where you can reach my team and all of our fabulous content.
Does anyone have any other questions? We have about 9 minutes left, so there's plenty of time if you want to ask our amazing experts.
I just wanted to clarify that we will get a copy of this PowerPoint slide. Is that correct?
I will verify with the presenters, but very likely, yeah.
Yeah.
Okay, thank you.
Mhm.
Thank you for this presentation. It was very informative and just appreciate all of your knowledge and bringing it to us. So thank you.
Yeah. And Karen, I don't know if you want to just talk about next week, but we are going to be presenting again next week with Judge Romero and I forgot the other person.
Dave Laban
Yeah.
from the Association of Prosecuting Attorneys. I believe I said that right, and I apologize if I didn't.
Yeah.
I think you might actually be on as well, Dave, if you want to come off the camera and wave hi. But we are going to kind of continue the conversation next week as well, but we're going to focus a little bit more on how this kind of more the state laws and how the federal Take It Down Act may or may not apply with the state laws on distribution of non-consensual dissemination of intimate images. So we're going to talk about what can prosecutors do, what can judges do, but it's going to be more conversational as well. So we want to know from you all what is happening in your jurisdictions as well. And we do have a question, it looks like in the chat. Can county circuit criminal and civil judges court order platforms to remove images? And then can the defendants or respondents be ordered to submit requests for removal? Anyone want to take this?
I can take a stab at it, but I'm not. I want to first caveat that I'm unfortunately not a litigator. So take it down itself doesn't give a state trial judge a new freestanding power to order a platform to remove content. The federal removal duty is triggered by the statutory notice process and enforced by the FTC. A state court, like as I understand it, may have separate injunctive authority under its own state law, but whether that authority can run directly against a non-party platform is, I think, a much more complicated jurisdictional due process, like First Amendment and potentially Section 230 related question.
And to Belle's point, this act is still fairly new in the grand scope of, the world. So I think we're also kind of just trying to figure out what can and can't the courts do. I know at least for the state laws, and I would ask Dave or Anne Marie or Judge Romero, I believe county judges can order, if it's a state law, they can order defendants to remove certain things, but I don't, again, know how much power they have over the federal platforms.
Yeah. And I think that's going to be part of the conversation we have next week, is why we brought them on to discuss actually that concept of state and federal and how it all works. So